The case of Macquarie Bank Limited and Berg is a very significant one in the world of internet law. It was a case that was handed down by the Supreme Court of New South Wales in 1999. The case's main issue is whether interlocutory relief can be awarded beyond the court's own jurisdiction. This case is significant, as the court wouldn't order injunctive relief over someone not in Australia. The facts of the case are as follows. The plaintiff, Macquarie Bank, was seeking the restraint of publication of defamatory material by the defendant Charles Joseph Berg on his website. Berg was a former employee of Macquarie Bank. Berg had been running a website named MacquarieOnTrial.com. The judge was satisfied that the material was defamatory. Berg was residing in the US at the time of publication, so this became an issue of jurisdiction. There were two main issues the judge had to answer. Whether the New South Wales Supreme Court can order injunctive relief to a person not residing in Australia, and whether or not the defamation happens in Australia if it's not published in Australia. In relation to the first issue, the judge acknowledged that there is authority to restrain conduct occurring outside of its territorial boundaries. She cited the case of Helicopter Utilities and Australian National Airlines Commission. Whether or not this power should be used was a question of discretion for the judge, determined by factors such as the potential enforceability of any order made, and whether or not another court is a more appropriate forum, also known as the Voth test. Justice Simpson held that the order would only be enforceable if the defendant returned to New South Wales, as he cannot be compelled to do so for the purpose of enforcement. While senior counsel argued that his return would be inevitable, the judge said that this still counted against making orders. She remarked that an order to take the content down would be pointless, as it was transmitted all over the world, and that an injunction would limit Berg's ability to publish anywhere in the world. However, Justice Simpson said unenforceability was not a determining factor in her decision. It was about the nature of the internet and where defamation occurs. She said that once the material is published on the internet, it is transmitted anywhere in the world that has an internet connection, and it may be received by anybody, anywhere, having the appropriate facilities. While senior counsel proposed to limit the injunction to New South Wales, Her Honour dismissed this as ineffective. Justice Simpson did not want to superimpose the law of New South Wales upon other jurisdictions where defamation laws may actually allow the content to be published. However, this has been criticised as the material was obviously directed to readers of New South Wales and probably wouldn't matter to readers in countries where defamation laws are different. However, the case of Gutnick in 2002 later clarified that the defamation occurs where the plaintiff is most well known and the damage occurs. The Macquarie case showed a non-regulatory approach to internet law, as the court refused to grant an injunction over someone who was residing overseas. However, this has been criticized as allowing a maker of defamatory imputations to evade court processes simply by publishing on the internet overseas. So on the question of where defamation occurs, this case has seen outdated and was clarified by Gutnick. However, on the question of imposing injunctions on people overseas, this case is still the main authority. This has been criticized as avenues such as private international law could have been employed. This case demonstrates the court's reluctance to offer interlocutory relief when jurisdiction is the issue. So this case deals with balancing regulatory approaches to internet law. So should the court have decided to impose New South Wales law upon another jurisdiction and tested the boundaries of enforceability of injunctions? Or should the court have decided that the internet is a boundary-free, difficult to regulate place due to different laws in different jurisdictions, as Justice Simpson leaned towards in this case? Well, I'll let you decide that.